suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
You certainly are going to need a good one. And we got one for you. David Whiting is our Melbourne solicitor who takes your calls, answers your questions and dispenses free legal advice. Good morning. If you're watching us on ABC Radio Melbourne's Facebook page, here we are. There's David. David, say hello to everyone.
Hello, everybody. I've got camera over there.
Got your own camera there.
Yes.
And also there's your microphone too. So we've got him, in stereo really. And we've got you as well. You can send in your legal questions. Best if you call us though, 0437 774 774 is the text number, but call me 1300 222 774 because we like to hear you make your case, and also David has those difficult, tricky, lawyerly questions that he asks in that always slightly impatient tone, David.
I'll do my best with you.
As if the clock is running.
It is.
It always is, let me tell you, it always is. Got any homework for us?
I had 2 pieces of homework from last week.
Yes.
There was Darren from Point Cook. His wife has been working for a company. She's basically been doing the same job for successor companies for quite some years, and she asked about her long service leave entitlement and was told that she had none. And the general proposition is that if you work for 7 years in the same job, regardless of the change of employers, there's a carry-forward benefit for long service leave, except there are a series of exemptions. So the first one is if you're entitled to compensation or long service leave under another Victorian piece of legislation, including the Construction Industry Long Service Leave Act. Yes. If you are entitled to an equivalent payment under an employment agreement, and if there's a dispute, you can go to the Industrial Division of the Magistrates Court. If the employer is a particular kind of employer who has been exempted, and that normally happens in circumstances where there is a equivalent or better system out there, or if you are employed under the Education and Training Act. So, for example, you're a work experience student. There are situations where you don't, where you're not eligible. And when Darren rang, we didn't get enough information to work out which one of those applied.
Okay.
Sharon rang. Sharon has a car in a company name, and if you get a speeding ticket in a company name, then you get a fine of $3,000.
Right.
If you nominate the driver, then it drops to whatever the right figure is, which is still horrendous, but less than $3,000. Sharon failed twice to fill out the paperwork properly. As a result, there's now a $3,000 fine against her company. And her question was, can we fix the problem? And the answer is, in practical terms, no. The Infringements Office takes a really tough line on whether you fill the form out properly, and their approach is, if you don't fill it out properly, you haven't done the nomination the way you were supposed to. So, sorry, Sharon, can't help you.
And the other one?
They're the 2 pieces of homework, but there's two law changes that come into effect on Sunday. Lots of people buy investment properties in a family trust or a discretionary trust. And a discretionary trust is where you don't actually identify the beneficiaries who will receive money by name, but rather as a group. So it's my parents, grandparents, children, grandchildren, brothers, sisters. It just keeps going. Now, the State Revenue Office says that if you are buying in one of those companies, one of those entities, and you sign the contract after the 1st of March, they will treat you as being a foreign trust. And foreign trusts who buy property in those circumstances pay stamp duty an extra 8%. So on $1 million property, you would pay stamp duty at 5.5%, which is $55,000. If you buy in a discretionary trust, then the stamp duty goes up by another $80,000.
Whoa.
Now, my bet is that every discretionary trust in Victoria will have a foreign beneficiary because there'll be somebody out there who's got a passport, and the only people who aren't foreign are people who are Australian citizens, Australian permanent residents, and New Zealand citizens on a subclass 444 visa. Okay. Right. No, but because where it gets caught, there's also a visa for a family member of a New Zealand citizen. They're a foreigner. They don't get caught by this. So that's a mess.
Total mess.
Well, sorry, it's more money for lawyers is my view,
Which equals a mess.
And only for some, though. And then there are changes to the guardianship and administration rules, laws as of the 1st of March, and they are... we've had the Act for probably 20 years. We've now revised it. It's now a more inclusive. The person who's being looked after has a lot more say than they did before.
Let's take your calls. 1300 222 774 is our number if you'd like to get some free legal advice from Mr. David Whiting. Steve is first up and he's in Ferntree Gully. Good morning.
Oh, g'day. My question, David, was privity of contract in regard to a retirement village unit. Is that a way out of the contract as soon as obviously the person that signed the contract is deceased? So for the beneficiaries and the executor, is that a way out of that contract? Because the unit is going to be held on to for probably 3 years before the money's refunded minus 15%.
Just before we get an answer, what's privity of contract?
The privity of the contract means it can only be enforced by the people who are parties to the contract.
Okay.
Steve, you will find that so what's happened is a resident has signed a residence agreement. The resident has now died, and there'll be a process under the agreement for the repayment of monies. Is that about right?
That's right.
And you're now coming along and said, well, because they are dead, the money's got to be repaid now. No, because the agreement will anticipate the death. And secondly, if you were to obtain letters of administration or a grant of probate of that person's estate, then you stand in the shoes of that person and have the same rights and benefits as if that person had simply left the retirement village.
Okay.
So it doesn't work. Good try. Doesn't work.
All right. No worries. All right. Thank you very much.
Okay, thanks for calling in. Carol is in Geelong. Good morning.
Oh, good morning.
Go ahead.
I have an A6 Audi with 129,000 Ks on the clock in very good condition.
I don't do valuations, I've got to tell you, Carol.
No, well, a week after spending about $5,000 on rego and full service, etc., we received a recall notice for the airbag.
Yes.
Yes.
It's a cart of airbags, yes.
That they said they cannot replace the airbags and buy back and offered us $3,100, which we refused that offer. And weeks later, we received another offer of $4,500. Obviously, still out of pocket just on the expenditure. What are my options?
Carol, it's a question of what the vehicle's worth.
Yeah.
It's not a question of how much you've spent on it and how much you cherish it.
Yeah.
It's the issue, and I've not actually worked out where this goes through. If you say, no, I don't want it, or no, I'm not going to take it, I'm wondering whether we reach some point where some government department says the vehicles are unsafe and have to come off the road.
Yeah.
I mean, we know they're potentially dangerous. We don't know in any individual case how it's going to work. So I'm at a different point, Carol. The question is, what's it worth? So if you were to look on a car purchase website, you might get some better idea of what your vehicle's worth, and I'd be going back to them and saying it's worth X. Now, presumably, you get back the registration money, so the renewed registration, which would be $1,000 or so. My guess is you get that back. The other issue is really just a problem of timing.
Yeah.
If you'd got the offer the week before you took it in to get it brought up to scratch, it might be a different discussion. So look and see whether or not your particular vehicle is going to be worth more than the offer.
That's right. Carol, good luck.
Good, thank you.
Let us know how you get on. David's called in from Listerfield. Hello.
Hi guys. Got a quick question about privacy. So I want to know if it's legal to record a phone conversation between a city council and myself as a citizen. So I can record the conversation, asking them questions about permits or planning or building sort of inquiries. Can I record that conversation? Because I know if
there are
it's a
two
private
answers to the
conversation-
question, David.
Mm-hmm.
So there are two pieces of legislation.
Yes.
It is an offence to attach a device to a telephone for the purpose of recording the conversation.
Mm-hmm.
Okay, so although if you do it on a mobile phone, my understanding is you've got the ability to record the conversation anyway.
But you can seek permission.
No, the
actual
attaching to the
attachment.
device, attaching a device to the phone for the purpose of recording it is a criminal offence. All right.
Okay.
Then there is Victorian legislation that says that you are entitled to you are entitled to record any conversation to which you are a party, but you can't use your recording without the consent of the other party.
Okay.
So
even though if it's a council, it's a public sort of matter.
no, it's a conversation that you're having in your particular circumstances. You have the right to record it. You don't have the right to put it on YouTube or on your Facebook page or wherever.
Unless you seek their consent.
Unless you get their consent, right?
So can I show it to, say, my friend, or can I show it to my parents?
Well, David,
next door neighbour.
David, are you wanting to show them the words used or the gist of the conversation? So I rang Council X, and Council X told me why. The person you're telling it to isn't going to call you a liar, so I don't know that there's any particular merit or benefit in the words. I actually have fun on the other side where all of these people ring you and tell you that they're keeping your conversation for training and quality assurance purposes, which upsets me greatly because everyone else who listens to it is getting paid. I'm participating in it and they're not giving me a cracker. But then again...
And they never sought your permission, they just told you.
But it's now information that they're holding about you, so you should be able to ask them for a recording.
What do you want it for, David?
Basically to show my neighbour. Just giving you an example, just to say, to show my neighbour that, okay, we had this conversation.
Are you in dispute with your neighbour about something?
No. Look, this is about a permit for a retaining wall.
Okay.
So the council wants, because there's an existing tree, and we're going to build a retaining wall underneath this tree. And
so are you talking to the council planning department or the engineering department?
Planning department.
Well, planning department isn't going to. The issue will be. It's really, does it not come down to an engineering question rather than a planning question? What's an appropriate retaining fence?
This will be a planning issue because there's an existing tree that the council wants to
preserve,
retain.
Yes,
and you can't excavate too close to the tree because it will damage its roots. So the council will want to say, you need to stay away from the tree by 4 metres. You need to provide a permit to do this work.
David, is it your planning permit or your neighbour's planning permit?
It's my neighbour's planning permit, which is affecting me, though.
Right, but if they're applying for a planning permit, that will be in it. You can get a copy of the planning permit by searching at council.
That's right.
When it happens.
I don't think the recording the conversation is the thing. Get a copy of the planning permit is really the issue here. Thanks for calling in. Vanessa has called in from Rosanna with an interesting one. Hi, Vanessa.
Oh, hi, good morning. I just wanted to ask a very simple question, David. And I'm just calling on behalf of a friend who's unable to get through she's currently at work. She recently completed a week's of work from 10 to 17 September in a real estate agency, and due to circumstances in the environment and so forth, she went to work on the Monday and resigned based on just took as effective of that day and left and gave them a resignation letter. And she's just a young girl and she's just not sure how she goes about it. And they've told her that they're not going to pay her for the week of the week commencing the 10th she worked Monday right through to Saturday. And they've informed her that they're not going to give her any money for that week that she worked based on the way she resigned. Is that correct, David? Does she have any...
She can't be punished for the way she resigned.
Yes.
And you would need to look at her engagement letter.
Yes.
And the engagement letter would talk about how the agreement might be terminated during a probationary period. I remember when I was at university, I had a job that I didn't particularly like, and I wanted to resign with immediate effect. And I was told that if I resigned with immediate effect, they were entitled to a week's notice or payment in lieu. So they would not pay me not only for the week but for not serving out my notice, I would be out by a week's pay.
That's exactly what they told her, yes.
Well, you need to look and see what the agreement says, and then I would be talking to the Fair Work Ombudsman because that's an incredibly unusual way of behaving in this day and age.
Yeah, she just ceased work immediately because
No, I understand. The question is,
What
was
the
she
agreement
required to give notice or a payment in lieu? I think it's pretty harsh.
Thank you for your time,
Thank you,
David.
Vanessa.
Thank you.
Good luck. No worries. Thanks for calling in. Michael's in Maryborough. Hello.
Good morning. About 16 years ago, I purchased 10 acres of land from a friend of mine, so there were no real estate agents involved. And a couple of years after I purchased it, he informed me that a small section of the land running along the north boundary was actually Crown land, which he'd fenced several decades earlier and had grazed his cattle on for those years. I got a notice from the relevant body many years ago saying, this is Crown land, are you interested in purchasing it at market value? And it's a very unusual shape. It's a wedge shape, and I wasn't interested in purchasing it for the price they were after.
Yep.
Is there any adverse possession claim that I can make since I've owned it for longer than 15 years?
Not against the Crown.
Not against the Crown, okay.
And
That's
the
all I
Crown
needed to know.
includes government departments and local councils.
Okay, thanks for that.
Pleasure.
Cheers.
All right, so that's the end of that one. Natasha in Phillip Island is an unusually brave woman. I think she wants to take you on about something,
Excellent.
David. Natasha, good morning.
Hi, good morning. Look, I love David, I'll just say, but on
However,
this
there's a
one,
however coming.
there is a however.
Uh-oh. You're a braver woman than me.
I may be. We have property in trusts, and so I freaked out when David said his thing, and I've immediately looked up the state revenue thing, and it's not, there's just more to it that David hasn't said, so I just don't want people to freak out. So after the March date, and I could say all the exact wording, but I've got it there, but basically if you can show that a foreign person will not benefit from the trust, then it's not a problem. You won't have to pay the extra.
It only applies prospectively, that is from the 1st of March. If you've already got a property, you don't need to worry about it. And they are telling you that you can modify the terms of the trust deed to say that despite the list of beneficiaries or the classes of beneficiaries, no foreign person, as defined in the Duties Act, will be a beneficiary or will receive a distribution.
And that's even after March 1st, though, right? So even if it happens
after... Oh, yes, you can modify
your
your trust deed. Yes, you can.
As long as you can prove to them there's no foreign people that can benefit from this,
yes,
then you're okay.
What I find fascinating, Natasha, is there's only one way to do it. My view is there ought to be lots of ways to do it, but they come along and say, you put this clause in your trust deed and you will be okay.
Yeah, that was the bit that, okay, good, I don't have to freak out.
Okay.
You see, there's very little that David Whiting doesn't know, Natasha. Very, very little.
Well put.
Good to talk to you. Thanks so much.
So
we have a developer with a fencing issue. Oh, the developers have been caught out by this eternal problem. It is, where's Atlas? Good morning.
Good morning.
Altas, I'm sorry. Altas, good morning.
Yeah, same thing. Yeah, good morning to you guys. I've got a property I'm building in Sky 10 townhouses, and the re-establishment survey is showing that the neighbor fence is about half meter on my property, and I cannot put the driveway now. And when I send a notice to her that I'm happy to change the fence in my cost, and whatever is the cost, I will cover it. And she claimed the adverse position. She said, no, I'm not allowed to change the fence.
Yes.
And she is the owner for only 4 years now. Is she can claim the adverse position?
If she bought the adverse possession rights, which is, if she was to acquire the rights. So what she's done, Altus, is she signed a contract that says, I'm buying this land. And the contract defines the land that you're buying by the title measurement. Right? So unless her contract of sale had her buying the receiving an assignment of the adverse possession rights of your property, the answer is quite possibly not. So it's a question of who can enforce the adverse possession rights. So if you were to find out who she bought from, and see if you could acquire their rights by that they could abandon for a fee their rights of adverse possession, you're in a much stronger position in your negotiation.
Okay, so what do you suggest now? Should I go ahead to change the fence with the notice?
If you go and change the fence at the moment, you're probably trespassing. And if you look at the Fencing Act, the fence says that the fence needs to go on the occupation line. Right, so we're really talking about what's the right line for the fence. I would go back to your lawyer or your conveyancer, and what you're interested in is working out what the adverse possession rights are and whether you can buy them from your neighbour's previous owner and thereby eliminate. So she's only got 4 years of adverse possession, which isn't enough, and not all the years before.
Okay.
Right, so let's say the person next door was there for 20 years. Before this lady who's been there for 4. They are the ones who acquired the adverse possession rights, and what they could do, they could abandon those adverse possession rights or assign them back to you.
Okay, I'm getting pushback on text saying, how come property developers get free legal advice on this program this morning? I'm not quite sure how big a property developer Altus actually is. Carol in Brighton, I don't think is some high-profile property developer. Good morning.
Hello. I've just got a quick one. I've got we have a driveway, and next to the driveway is a fence next to the next property, and they've planted something big there, and it started pulling the fence down a bit and cracking the driveway. And they're not interested. They don't even want to come round and have a look. What should I do?
You have an action for damages, you have an action to restrain a continuing nuisance, and you've got an action to fix the fence.
Right.
Right.
So what would you do first? Do it go to the council?
Now, council, the first I probably write to them and say, I've got these issues. The solutions are, we can either work out a solution or I have to take you, if I want my outcome, I have to take you to court, and I will, but I expect that it will cost us both a great deal of money, so can we fix the problem?
Okay, great. Thank you. So write to them first.
Yeah, so if there's a tree that's pushing the fence and pushing up your driveway, yes, they're all their issues, and you can get them to fix it.
And if that intransigence continues that Carol's already experienced,
then it's court, I'm afraid.
Then you speak to a lawyer and it's to court.
Yes.
Okay.
Okay, thank you very much.
Carol, let us know how that goes. If you're streaming us live on ABC Radio Melbourne Facebook, lovely to have you on board. This is David Whiting in action. It's quite something to behold, isn't it? We'll check in with Marcus Padley. I think the market upon opening has fallen about 2%. A lot of this is related to coronavirus, to COVID-19. Yes, I incorrectly called it COVID-20 at the top of the program. My apologies. I have fixed that. But I think we can take one quick more call. Sure. What do you reckon? Yep. It's another fencing question, but I'm always fascinated by them. Hi, Ray.
Hi.
Go ahead, Ray. Hi.
Sorry. Yeah. We're just completing building my son's house on a block with an empty block next to it. The owner of that block was going to construct a fence or pay for half of a fence to be constructed between the two, but now she's run into money problems and wants to sell it. So she says she's no longer interested in constructing the fence or paying for it.
Yes.
And that the new owners will happily go along with that.
Oh, no, not happily.
Yeah. my bet is like that's to get stuff because the fence is already there. What are our options? Can we make her pay for it?
It's a delicate dance. The question is, do you believe that you have an enforceable agreement under which she agrees to pay for half of the fence?
Verbal agreement.
Verbal agreements are fine, right? So, and have we agreed on what the fence is to be, or have we just agreed that there is a fence?
Basically, that there is a fence.
Then I'm reluctant to tell you to go and put it in. There is a provision in the Fences Act that says you can't construct a fence without an agreement or a court order. So self-help is an offence under the Fences Act.
Unless you put the fence inside your boundary.
Then it's not a fence on the boundary, and I still want one.
No, but it's still, if you decide to go ahead and do it yourself,
yes,
forget the neighbour, you can do whatever you want there.
You might need a permit depending on the height of the fence, but if we put that to one side, you can build the fence inside your property.
Yeah, but my son wants to rent the place out, and a secure fence line is
crucial. Yep, absolutely.
The fence is absolutely essential.
Get it? We've got to wrap up, so I'm going to let David comment.
So it seems to me that you either go to the Fences Act if the fence is already up, your new neighbour won't have to do a thing. So you need to deal with it with the current neighbour, either by an agreement. You might agree as to when the amount might be paid. It might be paid at the end rather than, from the settlement proceeds rather than now. That's where I'd be looking. David,
you're being described on text this morning, and I do love this. I don't know why it's taken us so long to figure it out, that you're the Hugh Worth of legal advice. Remember Hugh Worth dispensing...
Am I as grumpy?
Exactly right.
Hugh was beautifully grumpy.
He was beautifully grumpy. My favourite phrase of his, Madam, the problem's not the dog.
Okay.
Madam, it's the owner. David, thanks so much. Say goodbye to our Facebook audience.
Goodbye, Facebook audience.
Goodbye, Facebook audience. You can't even get the name right. Look, it's not his métier, but he does it very well. We're back with him next week, of course, streaming this live on Facebook at this time from 10 a.m, and we'd love to see you back here as well. Thanks for joining us, and thanks for all your calls. He will be back with that advice then. So if you can hang on to that legal problem until then, please do so.